Good morning to everyone. And since you've all replied, I assume we can all hear each other, and you can hear me and I can hear you just fine. We will hear the case of State versus Minor this morning. And this is the only one that will be heard by video this morning. Of course, we have other cases, but this is the only one that's scheduled for a video oral argument. As you both know, we will be live broadcasting this, and it will be also recorded and placed on our YouTube channel. So we want to make sure ground rules are kept, and one of the most important ground rules is that we don't mention the names of victims, or we don't mention the names of children under majority, obviously under 18. So the judges have read the briefs. We're ready to proceed. The appellant will have 15 minutes, and you can save up to 5 minutes if you so desire for rebuttal. You just have to let me know.
Thank you, Your Honor. May it please the court. Good morning. I'd like to reserve 4 minutes for rebuttal. My name is John Forstall. I represent the appellant, David Minor. As the briefs lay out, this is the issue in this case is Mr. Minor sought leave to file a motion to suppress. The motion to suppress was filed after more than 35 days after arraignment, and therefore we had to seek leave for good cause in order to file the motion to suppress after the 35 days per Criminal Rule 12D. Criminal Rule 12H allows a defendant to file a motion to suppress after the 35 days as long as the defendant has good cause. We feel that Mr. Minor has good cause. Significantly, this is the issue on the motion to suppress concerns Mr. Minor's Fourth Amendment rights against unreasonable searches and seizures. The video was not received until after the 35 days. So this issue was not known to me as his trial attorney. I did not know there was an issue with the stop until the 35 days had expired. It seems that the trial court is of the opinion that I should have asked for an extension under Rule 12D prior to the 35 days after the arraignment. It seems like the trial court has a prerequisite to ask for an extension before filing a motion for leave and then asking for a waiver for the 35 days. I don't believe the rules don't say anything about a prerequisite that they have to be read in congruence. It simply says if you have good cause, you can file a motion for leave. And I think it's significant to look at the timing, not only when the video was received, but the timing of the brief in opposition and the actual ruling. So I faxed in concurrently a motion for leave to file a motion to suppress and a motion to suppress on January 19th. I believe the briefs and my affidavit demonstrate the timeline of events, but I think some important things to point out. There was no trial date set for this case prior to our filing of the motion for leave to file a motion to suppress. The state hasn't shown any prejudice for if the court had granted the leave to file the motion to suppress. There was one pretrial, and that pretrial had been continued. Well, the first scheduled pretrial was continued by a couple of weeks because I filed the continuance because I had not yet received the video. And because of COVID, the prosecutor had changed their protocols for receiving a video. So instead of just going into the prosecutor's office to get the video, the office was actually closed. Nobody from the public was allowed in. So what they asked the defense attorneys to do is to mail a blank flash drive. They would download the video and mail it back. So that process took a long time. And that's what got us past the 35 days. The court was aware of that process because when I filed the first continuance of the first pretrial, I explained in that continuance that I had not yet received the flash drive from the prosecutor.
Counsel, let me just interrupt. I had a couple questions and I thought maybe you could help me with this morning. You talked about the fact you started before our technology issues arose. You started with your argument about the fact that you had not received the information until the past the 35 days to file your motion for suppress, and you also said that you had filed a motion for leave, but the court wanted you to file a motion for extension of time before you even filed your motion to leave. Now, I understand what your argument is. There's nothing in the rule that provides for that, but wasn't there a timeline, for pretrial motion to be filed that the court had issued?
Not that I was aware of, Your Honor.
I thought there was something that said that all pretrial motions have to be filed by such and such a date.
If there was, I was not aware of it.
Okay. All right, that's fine. I was just wondering. And then number two, let me just, even though you're not aware of it, let me just ask you this. If there was such an order, which I think I read about in the briefs, if there was such an order, then do you think that would be controlling, or would the criminal rules be controlling?
No, I think the criminal rules will still be controlling, Your Honor, because what Criminal Rule 12H says, and there's a related traffic rule, we can ask for leave and relief from the waiver anytime after the 35 days for good cause. So prior to receiving the video, I had no interest of justice issues, and I had no good cause issues to file a motion to suppress. The only issue in the motion to suppress is related to the video. There's nothing in the reports. There's nothing on the ticket. There's nothing in the ALS. I had no information on which to file a motion to suppress or to ask for an extension of the time to file a motion to suppress until I received the video. So I received the video on December 29, and that's the day before the rescheduled pretrial. I watched the video at about 11 o'clock that night, and when I got to the pretrial, I explained to, it was Prosecutor Campbell, that in my viewing of the video, there was no justification for the stop. And I explained to him that I would be filing, we couldn't come to an agreement. So I said, okay, I'm going to file a motion to suppress. He said, fine, indicated no objection. He explained to me that the judge would then, at the next pretrial, have us come into the judge's chambers, and I would have to make my case to the judge why a motion to suppress should go forward. So that was what I fully expected to happen at the next scheduled pretrial.
Counsel, let me interrupt you.
Yes.
Because that was another question I was going to ask you. So these conversations, though, were they off the record or were they on the record?
Oh no, they were off the record, Your Honor. Just prosecutor and I in the room there at the courthouse.
So there's nothing on the record that shows that you had intended on filing a motion to suppress.
Well, there is the docket entry itself from December 30th states motion to suppress expected. So not only was the prosecutor aware, the judge was, or the court was aware through its docket. And then that's why I filed the motion for reconsideration and provided an affidavit, Your Honor. So I'd argue that.
Thank you.
The affidavit also has that on the record.
Thank you.
And I think it's also important, there was a time waiver in this case. Again, there was no trial scheduled. The good cause is no video was received prior to 35 days. I had no awareness of any Fourth Amendment issues until I viewed the video. The motion to suppress is based solely on the evidence in the video. And, this would have been a very quick motion to suppress. It's a 2-minute video between the time the trooper following Mr. Minor to the stop. I did not challenge the execution and the demonstration of the field sobriety test. There's no issues with the breath test. It's solely the stop and then just the reasonable suspicion to pull Mr. Minor out of the vehicle and then the probable cause to make the arrest. So it would be a very quick and simple suppression hearing. And again, it's related to Mr. Minor's Fourth Amendment rights. Now, the other thing, just the timing. So like we had technological issues today, I faxed in to the court the motion to suppress and the motion to leave on January 19th. This was 2 days before the next scheduled pretrial. The first fax didn't go through. I got notice, so I sent it again. And then I went off to court, and I came back later that day and I got another notice that that second fax hadn't gone through. So the fax finally went through to the court around 4:30 p.m. The exact times in my affidavit and in exhibits to the motion for reconsideration. I emailed around the same time I faxed, I emailed the prosecutor the motion for leave and the motion to suppress. They obviously received it because they filed their opposition to the motion for leave also on January 19th. It was the opposition to the motion for leave was filed on the court's docket on January 19th. My actual motion to suppress and motion for leave were not filed until the next day because they didn't receive it till after 4:30 on the 19th. And the judge issued his decision also on the next day, on the 20th. So, and in his original decision, the judge stated that I only filed a motion for leave in response to the prosecutor's objection. That's obviously not the case. There was just an issue with the facts. And if the trial court had read the briefs, the trial court would have been aware that that wasn't the case because the prosecutor specifically refers to my motion for leave in their opposition. They actually quote from it. And then we had the pretrial on the 21st, and I didn't even know that my motion for leave was denied. Nobody from the court informed me, even though I was there. I spoke to Mr. Campbell on the phone, the prosecutor. I don't think he had any knowledge of it. He wasn't the one that filed it. And I didn't find out about it until I actually checked the docket about a week later. I never received the court's ruling in the mail. They only sent it by mail, even though at that time the mail had a lot of issues. I actually never received it in the mail. It just never came. But I did get a copy from the court in order to file my motion for reconsideration. But I think the court should be aware of the factual misstatements in the trial court's ruling. I did file a motion for leave concurrent with the motion to suppress. I knew I was outside of the 35 days. I believe we had good cause, and we think it's an abuse of discretion for the court to deny it.
Thank you.
And
You do
no
have.
Thank
Oh,
you.
I'm sorry. I thought you were doing it just perfectly. I was like, you have 4 minutes exactly left. Thank you.
Great. Thank you.
Okay. And for the state, 15 minutes.
Thank you, Your Honor. May it please the court, my name is Megan Philbin, and I am a prosecutor with the City of Medina, and I represent the appellee, the state of Ohio, in this case. The issue, there's only one issue that we're here for today. Did the trial court abuse its discretion when it had denied Mr. Minor's motion to suppress? And I don't believe it's disputed that the standard here is the abuse of discretion standard in reviewing the trial court's decision. I do think there is some kind of confusion that's being raised by Mr. Minor in that he's arguing some kind of merger between these the interest of justice standard with the good cause standard, and had argued that the trial court is somehow requiring that both an extension must be filed and good cause must be shown, which is an incorrect assessment of what was going on here. So the interest of justice standard comes from Ohio Criminal Rule Procedure 12D. So, and that is, there may be an extension of the 35-day time limit prior to it applies to extension of the 35-day time limit prior to expiration. So Mr. Minor was permitted to file an extension prior to that expiration of the time limit. And in this particular case, he did not do that. So we have Mr. Minor had entered a plea of not guilty on November 23rd of 2020. And then his motion to suppress would have been due on December 28th of 2020. In the meantime, in the middle there, on November 27th, the state had provided discovery to Mr. Minor and identified to him that there was the existence of this electronic discovery in the discovery packet that we had sent to Mr. Minor. Mr. Minor's correct. We did not send over electronic discovery immediately. It was something that had to be obtained in a special way because of COVID. We had been closed at the time, but we were sending out electronic discovery by mail, and it was taking longer. Taking longer to do that. So that being said, the motion to suppress in this particular case, it was due December 28th of 2020, but it was actually filed on January 20th of 2021. So since there was no extension sought prior to the expiration of that deadline on December 28th, then the interest of justice standard didn't apply here. So we sort of move on to what is available to Mr. Minor at that point once we're past that point of filing for an extension. And Criminal Rule of Procedure 12H addresses the failure to raise defenses or objections, and it indicates that if an individual does not file the motion to suppress within time, then that constitutes a waiver. However, it's not, Mr. Minor is not completely out of being able to raise the motion to suppress. He must at that point raise good cause to get relief from the waiver. So here, Criminal Rule 12H applies because we are past that 35-day time limit and no extension was filed. So I don't think anywhere the trial court really said that they required him to file the extension, but once he didn't file the extension, he was then required to get relief from the waiver, which was by providing good cause. And so that's kind of a clarification of at least the trial court and the state of Ohio's understanding of what the criminal rules of procedure are. I do want to note that there was some question here about whether or not the trial court had indicated that there was some other deadline that Mr. Minor had to file here. Like, did they set a specific pretrial deadline for motions? My understanding from the state of Ohio side of things was no, there was not a separate deadline the court had set. The trial court was following the Ohio Rules of Criminal Procedure and their deadlines. So that was my understanding.
Thank you.
So when Mr. Minor had filed the late motion to suppress, and then I believe he filed a motion for reconsideration once it was denied, the good cause that he had indicated to the court was the late receipt of the electronic discovery. He also indicated that there was a hope of some kind of resolution of this is a operating vehicle under the influence of alcohol case. And so I think there was some hope with the discussions with the state that there would be some kind of reduction in the case. And so that's one basis that he had raised. And also I think there was, in the motion for reconsideration, there was some argument that there was a heavy workload for that particular attorney who was handling the case. And the trial court considered everything that was raised in the initial motion and also considered everything that was raised in the motion for reconsideration here. So, and all of the conditions that Mr. Minor had raised, and in particular, the late receipt of electronic discovery, these were conditions that he knew of prior to the expiration of the deadline. So he knew that he did not have the electronic discovery, and he still did not file for an extension at that point. So it's at least the appellee, the state of Ohio's position that these were conditions that he knew of. He knew he didn't have it. He should have filed for an extension, and that is something that we routinely see in this court is individuals who know that they don't have everything, that they file for the extension and it's freely granted here. So it's also the state's position that this trial court thoroughly did consider everything that was put forth in front of them by Mr. Minor. They considered the initial filing and also his motion for reconsideration once it was initially denied. And I think it's important that the trial court had raised certain things that they didn't see in Mr. Minor's filings. So the court says there was no explanation for why there was no extension filed. They also indicate that there was no explanation of why an immediate filing, once the discovery was complete, was not filed. So once he did finally receive the electronic discovery, he didn't flag it to the court at that point. And then also, there's no explanation for why there was a 3-week delay. So why do we get it on January 20th instead of immediately once he became aware of the electronic discovery? Why did we receive it at that point, that it was so far along? So the court denied Mr. Minor's motion and indicated that there was no good cause shown for all of those factors to excuse all of the delay here. I do want to point out as well that there was some indication that the state of Ohio did not show that they would be prejudiced by the motion to suppress going forward. It's my understanding the state doesn't have to show prejudice in our filings. We don't have to prove that. So let me have one moment. I also just want to address one additional thing that was raised in the initial argument here. So there was some discussion as well that on December 30th of 2020, there's a docket entry from the trial court that indicates that that a motion to suppress was going to be filed. I just want to relay that is parroting what was submitted by the parties in their pretrial discussions. So once a pretrial is held between the parties, so between Mr. Minor's attorney and the state of Ohio, the prosecutor, those are held off the record, and the state of Ohio, the prosecutor, fills out a pretrial form, the conference report, just to indicate to the court what was the result of those discussions. And we'll frequently fill in there that the discussion that there may be a motion to suppress to be filed gets put in there, and the court will then parrot that language into the docket. Doesn't mean that the trial court was there or present or engaged in any pretrial discussion regarding a motion to suppress to be filed. So that was just so.
Well, at the very least, though, it demonstrates that the court was not caught off guard, nor the state or the prosecution as well, because at least that was something that was discussed with everybody, that there may be a motion to suppress file.
Right, and I understand that everybody is aware that the defendant may intend to file a motion to suppress. However, at the time of these discussions, the state of Ohio doesn't have the docket in front of us, and we don't have a calendar and marking for every defendant who has a case coming up for either trial or just the time limit is going to expire on the motion to suppress. We may be aware of it, but we don't check the time limit of things until the motion to suppress gets filed, at least I can only speak for the state of Ohio in this particular case. It only triggered for me to check it once the motion to suppress was filed by Mr. Minor. So, and I'm unaware of any obligation of the state of Ohio to inform a defendant through their counsel of when the time limit is going to expire. So it's likely that the other prosecutor functioned the same way as well, that we were not trying to keep up on that time limit for Mr. Minor. So I just want to say in conclusion, it cannot be said because of what the trial court in their judgment entries put out. It cannot be said that the court acted, demonstrated perversity of will, passion, prejudice, impartiality, or moral delinquency when they came out with their judgment entries regarding denying the motion to suppress. This particular court is very, trying to find the word, their judgment entries are very thorough, and they consider everything that's put in front of them. And I think that this trial court did explore everything that Mr. Minor indicated, and weighed it and considered it, and found that Mr. Minor did not have a good cause. And I'd ask this court to overrule Mr. Minor's sole assignment of error in this case. Thank you.
I think I just have one more question. What about appellant's argument that the judge was confused as to when the motion for leave to file the motion to suppress was filed? In other words, the judge said it was only filed after the state had opposed the motion to suppress.
Well, I don't know that that really has an effect on the ultimate argument here. Whether or not I objected when I filed my motion, was it filed prior to Mr. Minor filing the motion to suppress? My motion was filed in response to Mr. Minor's motion to suppress. I did receive it prior to it being docketed, but I don't believe that that has any effect on the ultimate decision of the trial court. They're basing their decision on the Ohio Rules of Criminal Procedure and the case law of the Ninth District Court of Appeals, and I don't believe that would have an effect on it.
I don't think I asked that question very artfully. What I was actually referring to was the fact that the trial court said that the appellant, the defendant, had only filed motion to leave to file a suppression motion late upon the state objecting to the motion to suppress being filed. So the court seemed to think that the defendant had not filed a motion for leave to file the suppression motion until after the state had objected.
Well, I think maybe I'm not understanding it correctly, but I think Mr. Minor had filed his motion to suppress out of time, and I think there was not good cause shown in his initial filing, and so the state filed our objection, and then judge denied the motion to suppress, and then from there a motion for reconsideration was filed, and in that motion for reconsideration there was good cause that was alleged by Mr. Minor, and the court considered that as well and denied it after considering that as well. So hopefully that addresses the question. Maybe I just don't understand.
That's okay. There's just case law that talks about the fact that if you file a motion to suppress and then the state objects to it, and then the defendant then files a motion for leave to try to show good cause, that may be treated a little differently by the court. That's all I was getting at.
Oh,
okay. Well, thank you so very much for your argument. And you have, appellant, you have 4 minutes remaining.
Thank you, Your Honor. May it please the court. Yes, just to be, so the record is clear, the motion for leave was filed at the same time I filed the motion to suppress. I understood I was outside of the 35 days, and that's why I filed the motion for leave. And in the original motion for leave, I did provide good cause. The good cause is simply that the motion to suppress is based solely on the video, and the video was not received until 35 days had passed since the arraignment. The trial court did, and the prosecutor did mention that the trial court seemed to have problem with the 20 days between the December 30th pretrial and the January 19th, or let's say January 20th filing of the motion for leave. I don't think that was an unreasonable time delay. And importantly, it was filed before the next pretrial with the court. So again, my understanding was that at that next pretrial, we would have had a discussion about the motion to suppress. And in addition, the prosecutor was aware of the pending motion to suppress, and the court, through its docket, was aware of the pending motion to suppress. And just to be clear, I do understand the rules. I do understand the difference between an extension in filing out of time and asking for a good cause. And I still believe that the trial court misinterprets those rules. What the trial court said in its first denial, well, part of the reason it denied it was that I didn't seek an extension prior to 35 days. I don't need an extension filed at 35 days if I have good cause that I discover after the 35 days, which is what this is. The good cause is Mr. Minor's Fourth Amendment rights were violated, and we were not aware of that until more than 35 days after the arraignment. So if this doesn't...
Counsel, I'm sorry. Isn't that something the court could consider in regard to whether it was good cause, though? Because you knew that you did not have the video yet, and you had requested it, so you could have asked for an extension of the pretrial motion deadline under the criminal rules.
Yes, But I didn't think it was necessary, and I'll explain why. I did ask for an extension of the first pretrial. I asked for a continuance of that first pretrial because I had not received the discovery. At that moment, the only evidence I had was the police report. And based solely on the police report, I had, in my estimation, no interest of justice issues to ask for an extension of the motion to suppress deadline. And I think it's important to note that the 12D 35-day deadline is not a hard deadline. It can be we waive the issues, but they can be reinstated based on good cause. So I practice in courts all over Northeast Ohio, and in trooper cases especially, we tend to get the videos more than 35 days. I have never filed an extension for the interest of justice if I don't have an interest of justice. I didn't have an interest of justice prior to 35 days because I wasn't aware that it was a bad stop. So once I was aware it's a bad stop, to me, then that equals a good cause to grant the leave to file the motion to suppress. Every other court that I've ever practiced in does that, and no other prosecutors file objections. And I think in this trial court specifically, the state kind of gave away the game here. What the state said was, when a defendant files a motion to suppress, that triggers me to check the dates. The prosecutors are aware that the court has a very strict, and in my mind, a blanket rule that is outside of the rules of criminal procedure, that if you don't file within 35 days, you don't ask for extension, then I'm not going to grant leave. That's what this trial court does. And that's not what the rules say. The rules say if you have a good cause, you can file after the 35 days. The trial court just ignores that. And the trial court even said in their denial, well, if you just ask for an extension, this court freely grants those. But again, I didn't have an interest of justice issue prior to 35 days because I didn't have the video. And I'm not in the habit of filing what I would consider a frivolous motion asking for an extension of time that we don't necessarily need. Once I have the information that to me equals good cause, then I would file the 12H motion for leave, which is what the rules provide you to do. So the prosecutors know to look for the 35 days, and then the prosecutors have a rote objection that they file. And frankly, the trial court has a rote denial of motion for leave that it files. And we know it's rote because the trial court didn't understand that a motion for leave was filed prior to the prosecutors filing their objection. The trial court was not aware that the prosecutor actually quoted from my motion for leave in their objection. The trial court
Counsel, you need to wrap up.
Okay, and if you look at the cases cited, all the cases cited by the trial court and the prosecutors were cases where there was no motion for leave, or the facts used to justify the motion to suppress were known prior to 35 days. That's not the case here. The facts weren't known until after 35 days, and we did file a motion for leave. Thank you.
Thank you. The court will take the matter under advisement and issue a written opinion, and that will be sent out to both sides, as well as you can look for our release electronically on our website and the Supreme Court website. Thank you both for your excellent presentations. We appreciated it this morning, and we appreciate you being so patient with the court as well with everything going on. So I hope you have a good rest of your day.